Good morning, good morning, everyone. Mr. Chetan Nagendra, sir.
Yeah, good morning.
Yes, sir. Sir, can you please go ahead, sir? We are live right now, sir. Please start the
Sure.
program, sir.
Thank you, Mr. Robinson. Good morning, distinguished speakers, to ASSOCHAM functionaries, participants from the Government of India, and to all other participants. We have a very exciting and timely masterclass on intellectual property today. We also have a galaxy of respected speakers. As you know, IP is the bedrock of a growing company, and I sincerely wish that the participants take with them critical aspects of IP from today's session, so that they may be so that this is valuable for them to growing their organizations. We also welcome the Government of India's representatives to today's session, so that they may share their vision of helping startups grow this great nation. Now, without much further ado, I welcome Shri Ashish Agarwal, who is the Director of Lada Financial Services, to provide the inaugural address. Over to you, Dr. Agarwal.
Thank you, Mr. Chetan. Yeah, good morning and very warm welcome to all of you on behalf of ASSOCHAM. So, as you know, ASSOCHAM is in country more than 100 years old chamber, and it is having more than 450,000 members from trade and industry across. And ASSOCHAM is functioning through the council. So ASSOCHAM is having many councils within it. So like this, there is a council called Startup Council, which is helping startups in many ways by way of connecting with the industry, by way of providing mentorship, funding support, and then networking and many other ways we are helping the startups in this Startup Council. And the Startup Council has started a elevator pitch series. Launchpad elevator pitch last year, where we have to tier 2 and tier 3 cities to connect with the startups. We invited the startups from these cities to pitch their business plan in front of the investors and the other stakeholders. It was a great success where we got almost 1,500 startups from these cities who almost 300 startups have given their pitches in that live session. And out of that, we have selected 36 startups, and we will organize the grant school for the startups. So this is the series which was a great success of the Startup Council. In continuation of that, we have started organizing masterclass on various topics or various subjects for the startups. So we have in the last one and a half months, we have organized a masterclass on mentorship, on the other subjects also. In the same connection, this today's masterclass on the IPR is a very important subject. And ASSOCHAM has invited the participants from various backgrounds, so the startup founders, the mentors, and the industry people, and other stakeholders. So this is a very good platform where all kind of startups, all kind of stakeholders are there on the platform. And today is a very special day for all of us. We have a great speaker panel where all the panelists are having very good background or very good experience in the different areas. And we have panels from BPIIT, NACI, and the today subject experts from the successful lawyers from the large law firm. So that is a great honor to ASSOCHAM that the people you like you have joined us for this program. I would like to welcome all of you. Sri O.P. Gupta ji from BPIIT, Sri Ajay Kumar Garg ji, Senior Director from Ministry of Electronics and Information Technology, Government of India, Sri Akhilesh Kumar Rai ji, Partner AZB, Sri Nishat Nadkami ji, Partner Ketan and Company, Ms. Archana ji, Partner Oman and Associates, and Sri Sarvinder Singh ji, Senior Partner Kuchar and Company, Sri C.R. Jacob ji, Senior Strategic IT and Business Electronics. We have Mr. Dr. Bhattacharya ji, Partner Senior Partner, and Ms. Suchi Agrawal, then Partner IPUT. And we have Dr. Venkat, Advocate, RBI Associate, and Sri Chetan Nagendra ji, Partner CDS Legal, who is our moderator also today. So thank you very much to all of you for joining with us in today's webinar and sharing valuable time. I would like to welcome from one of my heart to all the attendees who have participated in large number. I am seeing that number has already been more than 250 participants are already there today, Monday morning. So I would like to welcome all of you. And this startup is a good topic. So as you know, that startups have recognized the power of innovation, ideas, and technology. And idea is the most valuable asset in the balance sheet of any startup. So this is a very important topic for us. As part of the startup policy, Government of India has started a scheme for facilitating the startup intellectual property rights called SIPT. Cover detailed guidelines to promote and encourage startups for IPR protection. So I think this is already elaborated in a big manner. So today's masterclass, we will discuss, Chetanji will take forward what is IPR. A lot of questions are there in the mind of the startup. So what is IPR? How does the patent give protection worldwide? What can be patented? How to prepare and file application for IPR? What is the sums of patent? So these are some of the issues which I think will be discussed here also. And I would like to again thank you to all the participants and all the panelists for joining with us in today's webinar. And I request Chetanji for taking it forward.
Thank you, Ashish, for that wonderful introduction. Just before we start the session, I wanted to sort of like inform the participants that they can type their questions, in the chat box, and essentially, for a respected speaker or for the group, and I'll take it up during the course of today's session. So the format of today's session is that each of the speakers will be handling about 2 questions which are relevant from an IP perspective and to startups. So to begin with, I welcome Dr. Venkat Reddy. He's an advocate and also a part of RVR Associates. They're IP attorneys and advocates. So, Dr. Reddy, do we have you?
Yeah, thank you, Mr. Chetan.
Yeah, good morning, Dr. Reddy.
Morning, sir. Thank you, sir.
Sure.
Yeah, this is with regard to the being an initial speaker and the first speaker, and also thanks to the ASSOCHAM for putting me on the board. And this is the startup and IP is such an interesting subject. And it is broadly said that if you fail to plan the IP in startups, you are failing to you're planning to fail yourself in the startups, because most of the startups with the experience goes, this is because where they invent something but they don't document it properly, then they are the losers. So there is a very interesting and important subject, because the India is taking up this very seriously as Make in India and Startup India. And interestingly, the topic given to me is saying something about what is the basic intellectual property rights. The intellectual property rights are the patents, copyrights, trademarks, geographical indications, and designs. It put it in very precisely to understand everyone. Let us take the example of the Sprite bottle, where the word written on the Sprite as is called as a trademark, and the label which it appears looks like is the copyright, and the bottle design, even nothing is written on the bottle. If you just look into the green bottle with the dots, you say it's a Sprite bottle. That is a design. And the most important aspect is the patent. If somebody puts you in the transparent glass and gives you that ingredient of the Sprite, you say that by tasting it is a Sprite. It is as simple as for understanding purpose. But the question is here how the startups are related to this. But with the startup, once the startup itself indicates that the basic idea, somebody gets an idea, and idea to be modified into a reality is the most important. That's what is the role of the startups. But the problem is when you create something, most of the people forget about the documentation, because when they do something in the industry to develop something, they takes care of everything like financing and taking of the infrastructure development, employees, everything, but they really forget in documentation in the form of IP. It is something like I put it, because a good film writer goes to a producer to tell his story. The producer says, no, I don't like this story. But after 3 months, surprisingly, you find that film on the screen with your story. So because after later on, there's a best example you can say, like the 3 Idiots and all those films. So the problem is when the startup, somebody creates something, when they take it to the financier or venture capitalist or funding agency, you may not be dare enough to say that to enter into a non-disclosure agreement, but you can do some sort of documentation, because by doing the documentation, you protect your ideas. When ideas comes out initially, it looks very easy, but when then you get into reality, today some of the best examples I can quote is Amazon, Flipkart, and Ola, or what you call even Zoom in the present scenario, in the COVID scenario. And you will also be shocked to know that today the richest persons are the persons who have something started like the startups, some startups only. So you suppose today the brands, you say that when you think of the brand of Apple, I'm surprised to see that it is the cost of the Apple brand is at $205 billion, not the company you're purchasing, only the brand APPLE. So how famous this brand is. And you're also surprised in the copyright matter. Always I quote the example of the J.K. Rowling, the author of Harry Potter. Her income is in the by way of royalty $1 billion. It will be quite shocking, because nowadays the people should be a smart working, not the hard working. It should. That's how because the question is, the whole concept of this seminar is that you do something, you develop something, but you do it the proper documentation. What you have to do is better to go for a good IP lawyer, and then take the documentation perfectly. Everything you do, please put it in documentation, because when the matter goes on litigations, many people end up in the litigation, improper documentation. It goes to the litigation, it is very costly, because when the matter goes to the courts, advocates play between full stop and comma and word to word. And when initially the people, not only the IP, the startup industry and everybody, because the documentation is very poor. Now the topic given to me is also with regard to the what are the things to be looked into when the matter goes for the licensing of IP and all. See, normally the licensing of IP, when most of the people do invent something, they may not be good entrepreneurs to put it in a reality. And when you want to sell it out, your idea, once you put it in the reality, the best way is to go for the assignment, where you can completely relinquish your rights by reducing it into documentation to someone else. And there is something like licensing, where you can retain your rights with you, but you can permit the other party to operate for the particular geographical area, as well as a particular period of time, that how the franchisee agreements and licensing thing happens. But the question is, when you are going for the licensing, you should be very conscious about your product, and they should something like the win-win situation when you go to the fundraisers, and you have to have a bargaining sort of thing, and what kind of the power your invention has got, and the way of bargaining for the royalty, or way of the bargaining for the investment and percentage of shares. And second important aspects, probably the inventor may not be alone, maybe is associated with employees, or maybe associated with some of the partner, or some sort of understanding with other person. Under those circumstances also, there should be a documentation is very important to understand the terms and conditions among the partners, and to reduce into writing either way of licensing as well as the assignment. Now coming to the point, what the government is doing for this. Interestingly, India is the third most the populous country, and the popular country in the sense of the in the startups, because after US and China, India is coming up like anything from the startups. And many of the governments are encouraging, and the government of India itself has put up the fund of 10,000 crore rupees. And also with regard to we are concerned about the today IP related topic with regard to the startups. And when you file an application, see that 80% rebate is given in the patent filing, and 50% rebate is given in the trademark filing. Most of the startups entrepreneurs may not be aware of this. And also the government have a facilitation, the team has been created. If you get into the website of the IP, that ipindia.nic.in, there are the facilitation people who are enrolled with themselves, the counsels and the advocates who will be providing the services, whose names are registered in that. So the government, other than that, the tax exemption for 3 years is being given. Also, when you participate in the government tenders, also the prior experience, those sort of things are being waived off. Now, the important aspect out of this is, because ultimately the whole crux of this is when you create something, you may be a good entrepreneur, you may be a successful personality, but you have to do your documentation very perfectly. And this is the most important aspects of the whole IP. And my co-speakers will be covering many other topics, and I'm just confining myself to this: what are the types of IP and the benefits given by the government, as well as the precautions to be taken on the license. And Chetan is my precise presentation within the given time, because I'm constrained to speak for the 7 minutes.
Sure. Thank you, Dr. Reddy. I think thank you for providing an overview as to what are the different kinds of IP and what are the, an overview about licensing of IP which is produced by startups. Now I invite my next speaker, Ms. Aparna Karir. She's a partner at Oman and Associates. Aparna, are you on?
Yes.
Okay, Aparna, thank you. And can we proceed to the next slide, please? Yeah, Aparna, I wanted to ask you, so how should startups go about their IP strategy?
So in terms of IP strategy, I'll take, through you guys through some of the important things that have to be kept in mind while making an IP strategy for your organization. So before I do that, I'll just like to thank ASSOCHAM for giving me this opportunity and for all the participants for taking out their time. So as you're aware, and as it's been told before, IP is one of the most valuable assets that any startup will have. And sometimes what happens is that in all of the aspect of getting hiring right people, getting your finances in, you sometimes forget about IP. That's the last thing in your list of things to do. However, because it's such an important aspect, companies and organizations, especially startups, if they have in place a strategy that they follow throughout their life, then it's easier for them to not only put in their IP, but actually to gain some value from the IP that they have created. Some of the few points that I like to stress upon is that the first and the foremost thing that any organization needs to do is to identify that an IP has been created. Now, as told by Dr. Reddy, there are various kinds of IP that can be created. You can have new inventions. You can have a new design of a product that may be very unique. You may come up with new logos or designs. You can have a new website. You can have a lot of written material. So all of these are considered as IP and can be protected in India and all over the world. So firstly, identify what kind of IPs you've created and make a list of those IPs. Always good to have internal discussions, be a part of such organizations and that help you through creating the IP. Also, make your employees aware of these various kinds of IP that that can be created. The second step is it's capturing of an IP. Now, how do organizations ensure that once this IP is actually created, it is actually captured? One of the easiest method that is used all over the world and in most organizations is that you have a simple form for all your employees. You yourself may fill up a few questions if anything new comes up. You have questions like who came up with the idea, what's the idea. You can even put in a few diagrams, put in a few paragraphs. This basically ensures that whatever IP has been created is put into a document. And as Dr. Reddy had mentioned, and I'm sure all of the panelists will again and again mention, what is important is you document everything that you have created. And this is a good way of documenting. Make sure that these forms are signed by people who have filled these in. All of a date is put in to ensure that you know when the IP was created, who was part of the creation of the IP. Also, a number of times, we'll just have an informal discussion. That informal discussion may result in a great idea. Again, it is important to put all of these in documentation so that nothing is lost. And in case litigation happen later on, then you have these documents in hand with you to defend your IP, saying that this is what I've created and I have documentations to prove that the IP has been created by our organization. The third aspect that I like to talk about is making sure that the IP remains in your organization. Now, how do you do that? As you'll all be aware that coming up with a new product is not a single person's job. There are a number of people who are involved. There are employees that are involved. There may be some outside parties that may be involved. There may be maybe a government organization that is involved in all of this aspect. So, when you get into any deals of such sort, firstly, with your employee, please have an agreement stating that any invention that they make will belong to the organization. They do not disclose any information outside. Explicitly have some assignment in saying that this invention is given to the organization. With third parties, also make sure that what belongs to which party, which is your IP, which is their IP, what have they come onto the table with. So documentation is very important, making sure that everything is in place. Another thing is that if you do plan to file anything together as a co-partner, again, make sure that you already know beforehand who will be paying for the bills of the attorneys, who will be paying the official fee, who will be taking care of renewals, because all of these can become very big issues and contentions later on. So if taken care of in your IP policy beforehand, then it's easier later on to deal with these small issues, and they don't become too large. The next aspect, once you have all of this in place, is protecting your IP. Now, IP can be protected in a number of ways. You can file a patent for something that is a new invention. You can file a design application for a new and unique design. You can file a trademark for a new logo, for a new name, and you can file copyrights for all the content that you have on your website. So make sure that everything is protected in a sufficient manner. Patents can also be filed. You can file a single patent for a particular product. You may have multiple patents for that same product. Having multiple patents makes sure that the product is kind of protected by all ways and means. So if possible and if permitted with the finances, try and protect all aspects of IP. You can if you can have offensive patent strategy, that means you can block your competitors. You can make sure that they do not file anything, they do not block you. And you can have defensive patent strategy, meaning that you can protect your own turf and make sure that nobody steps onto your turf. Finally, decisions have to be taken whether you want to keep the patents in India or file outside India. I'm sure other speakers will take you in detail through these aspects. And before I conclude, just one aspect that is to be kept in mind: please keep checking your portfolio every year. Look at the portfolio, see what patents make sense to you, and see what don't make sense to you. That don't make sense to you, you can probably let them go or give them out for licensing. And last but not least, check if you're stepping on anyone else's toes. Again, I'm sure somebody will take you through in detail of what needs to be taken care of. That's all from me. If there are any questions, I'll be open to them. Thank you so much.
Thanks, Aparna. That's a very comprehensive overview. Very quickly, in terms of like your experience, most startups, when they deal with larger companies, enter into NDAs, correct? How critical are these? Should startups be wary of signing NDAs? What are the things that they need to look at? Just a very quick answer, please.
So whenever getting into an NDA or an agreement, make sure that what belongs to you is spelled out in that NDA, so that your rights are protected later on. Whenever you get into an agreement, those aspects have to be looked at, and I would always suggest that and advise that you have a lawyer look into these aspects, because they may be the right persons to look into the nitty-gritties of any NDAs that you get into.
Okay, thank you so much for that. Now, moving on to the next topic. I welcome Shri Akhilesh Rai, who's a partner at AZB and Partners. So Akhilesh, do we have you? Akhilesh, you may be on mute. Hi.
I'm audible. Hello.
Yeah, you might need to speak up a little bit, Akhilesh. But very quickly, there are two topics and very interesting ones, which are very relevant to startups. On the first one, if for instance, if a startup, seeks funding and essentially, they seek out venture capital, and they end up sort of like negotiating deals with venture capitalists. Under the documentation which they sign, who ends up owning the IP?
Okay. One, we need to first understand when if a venture capitalist is like a bank who just would like money to make more money. They don't have anything to do with the ownership of anything. They just buy into the equity of a company or an organization, which is basically to take the investing company to the next level of business where we can expand, generate more business, etc. More often than not, and especially in the Indian scenario, what we see is that venture capitalists ask a lot many questions which are irrelevant, so to say. And there are situations where like they say that whatever the company develops, they would want to take it out to have it in some other company that they will have licensing. The problem with startups is that invariably they agree to such irrational demands because they want the money to come in as soon as possible. What that results in is that going further, chances are that the business will just collapse because the benefit of those IPs are being taken by the venture capitalists into some other company. So one needs to understand that the venture capitalist is not investing in your IP or developing the IP. That is yours as in the investing company. And the rights to that IP remains with you. The profits made out of the business is what the venture capitalist can take once that entity decides to exit the company or set listed.
Thanks for that. Sorry, go on, Akhilesh.
I couldn't follow what you were saying.
So typically then it boils down to the documentation, and essentially, startups need to be careful as to who ends up owning the IP that they create, especially when they're seeking investments. Is that right?
Correct. In all situations, the IP should remain with the company. There can be no way where the venture capitalist enters into a contract with you where they can take the money out for the IP out.
So one question which I have is, let's say there's a co-founder in a startup and he brings with him technology, or he contributes technology as part of his bringing value to the company. In such situations, what do companies need to do so that the technology can belong to the company itself?
Cheating, that is in a different way altogether. When we talk about venture capital and a co-founder or a co-developer, that is a different ballgame altogether. Now coming to a situation where there is a co-development of any IP, as per the IP laws, the rights are divided between the parties. And in that agreement, whenever a co-founder is wanting to exit the company, that aspect has to be, factored into the document on day one when the document is being prepared. In these cases, and like most of the panelists sitting here, especially into litigation with the arbitration work, you'd see that in case of any dispute between co-founders, the biggest issue is that who owns the IP. Because more often than not, and in the Indian scenario, this aspect, if you see the older contracts, and even now sometimes, that in case of dispute, the ownership of IP goes to who is not factored or captured into the document.
Understood. Now, just moving into M&A situations, what are the typical considerations that need to be taken into while concerning IP in a traditional M&A structure, or which is more typical in startups worlds where acqui-hire situations come up? So, what are the things to keep in mind?
So, this is a question which most of the analysts will agree that in a typical M&A situation, there is hardly any consideration according to the IP. Invariably, your IP is as part of the slump sale or as part of the entire business, where machinery and everything is there. We keep suggesting to people that it is important that, and I'll come back to that. The reason for that is that during the life of the company, before it being acquired, nobody was bothered to actually accord any value to the IP. You will not find, if you see the top 100 brands of the world, there hardly is any Indian brand which finds mentioned there. Even a company like Tata's, their brand doesn't feature there. That is the approach that will happen. So my suggestion always is there is a science to which valuation of a brand or IP is done. Once a company has reached a particular level, a startup, it is always better to have value according to their IPs. And in a normal situation, IP is sold as not part of the entire business, but asset in itself.
Understood. I think those are very valuable comments, and I thank Akhilesh ji for his comments on these matters. Now, moving on to another interesting topic, may I request Shri C.R. Jacob, who is a senior strategist at Lexorbis. Mr. Jacob, are you there?
Yes. Am I audible, Chetan?
Yeah, yes, you are. Thank you. So one of the things is we are going to be speaking on protecting IP internationally. And there is also a crossover from the previous speaker on how to tackle IP diligence during VC investments. Now let's take up the first topic. So, in my experience, a lot of the startups, that I encounter, they'll come and say, I want to register my IP in the US. I want to move to the US. That's typically the scenario. Or I want to register or set up a holding company in Singapore and so on. So should startups actually think of protecting IP in India if they are going to be based in India prior to venturing overseas?
Okay, first and foremost, thank you, ASSOCHAM, for this opportunity and for organizing this program. To answer your question, Chetan, I think we should look at from a different perspectives. So first and foremost, we all know India is an emerging economy, and we have a large domestic consumption. And if you look at our GDP, a large chunk of our GDP owes to the domestic consumption. So that would be the first, biting point that IP has to be protected in India. If you're making it in India, then please protect in India. Now, looking at from a technology perspective, if you look at people who are in this industry for more than a decade or two, earlier we used to tell, and so we know that software, as per Patents Act Section 3K, so we don't have, software patents were not allowed. And so a decade or so back, so we used to tell our clients, okay, if you have a software patent, it's better you go and file in the US and things like that. But today we have the patent offices much more open. We have the CRI guidelines in place. We also have a recent judgment by eminent Judge Pratibha Singh, all indicating, giving, kind of signaling the industry that, hey, we are not averse, but yeah, there are certain guidelines. There is we can, based on technical merits and all that, we can actually look into all those aspects. So it's all the more giving confidence to the startups that okay, there is a wide area of technologies that India is definitely a market. There could be an exception. So one exception could be on the semiconductor front. We are actually trying to bring a lot of as per the Make in India program, we have that policies in place and all that. But still, there are startups who are designing semiconductor chips. So in fact, for them, India probably may not be the market because their manufacturing happens somewhere in Taiwan, maybe TSMC using TSMC, or in the US using global foundries. So for them, it does make sense that they have their patents first filed, they take a foreign filing license here, and then have their patents filed in the US or in Taiwan. But barring that industry, so India is the market for startups, and so they need to file their IP in India. So another point is on the regulatory front. So we have the Startup India program. So there are a lot of incentives. So I think I'm echoing what Dr. Venkat Reddy sir said and Aparna ma'am said. So so we have a lot of incentives given by the Startup India program. One thing that people don't realize is that there is also the Income Tax Act, which under Income Tax Act earlier there was a section 80 RRB, where your royalty income from IP licensing, so that is reduced. I mean, that is on. You could actually waive off up to 3 lakhs rupees, and then later on in 2017 you had the section 115 BBF coming in the Income Tax Act. So under that section 115 BBF, you could actually the royalty income from your IP would be actually taxed at 10%. So there are various. So government is trying to bring an ecosystem and trying to woo the startup, saying that hey, we have the policies in place, and now you start protecting your IP in India. I think my advice to startups would be to if you are manufacturing in India, if you are making it in India, file your IP in India.
Sure, Dr. Jacob. I think there's an interesting conversation around equalization levy and royalty these days as well. As you rightly mentioned, royalty is at 10%, and the newly introduced equalization levy is at 2%. So there may be an arbitrage there.
Correct.
Have you come across any situations while advising startups in this regard?
Not yet. I think we are still in a very nascent stage. So in terms of the repatriation of the money, if you're talking about, we do have a certain limit onto that. The SEBI, there are the SEBI guidelines. Had the 2% bar on that. But otherwise, on the 10% royalty, we are yet to see of startups, commercializing and getting the royalty out of it. So yeah, we're still in the nascent stage.
Understood. Thank you. I think just moving on to the next sort of like question. So most startups are quite concerned about higher valuations now, especially in COVID-19 situations where valuations are depressed. Does IP really help them gain an additional valuation? So when they're looking at fundraising, what do they need to be wary of from an IP diligence perspective?
I think we are addressing 2 points or 2 sides of the same coin here. So one, let me just talk about IP diligence. So typically, if a startup is trying to raise a funding, let's say the startup is in around 2 years of operation, and they are bootstrapped and now, or maybe seed funded, and they are looking at a Series A, Series A, about 1 to 5 CR of investments. So typically, the investors or the agency, the funding house, would employ a reputed law firm to do the due diligence. And when a law firm does a due diligence, typically what they look into, the first and foremost is on the ownership of IP. Is it residing with the startup? The second aspect is on the regulatory compliance. Are all the forms in place? For example, if you're talking about patent filings, then is your Form 1, Form 2, have you filed Form 3, or every 6 months have you filed the Form 3s, and Form 18, Form 26, Form 27, if you're, and Form 28 if you're a startup. So all those forms, so are you compliant with respect to that? So this is primarily the due diligence that they do. If you are at a much larger scale, and if you are looking at a PE, private equity player coming into picture, or if it is M&A, if you are an exiting at that point in time, then probably they might do something called the product to patent mapping, just to make sure that the patent is what they are trying to claim in the patent is actually mapped to the product. Apart from that, they might also do an infringement analysis. So this is the whole package of due diligence that they will be doing on an IP perspective, from an IP perspective. Now let's say the startup, coming to the valuation front, typically can startups, so these the due diligence aspect is a precondition for you to get the funding. Okay, Now that doesn't mean that the startup is going to the investor is going to value your IP more. So how do you pitch to the investor? How do startups pitch to the investor saying that, okay, hey, I have this IP. It's a, let's say there's a patent backed product, and so I need to get so my valuation is much higher. So how do you do that? So basically you do the valuation. So there are typically different kinds of valuation methods. Let's take the example of discounted cash flow. And then you actually, when you do a discounted cash flow analysis and you do a forecasting of your revenues, you actually tell that, okay, if my IP was not there, or let's say there's a competitor in the market, and the competitor has so and so revenues for the last 5 years, and now I'm having a niche product in the market, and so this will in fact I will get a larger market cap, and so because I have a larger market cap, of course my my profit after tax increases, and there's a larger valuation. So that is the pitch that you need to do when it comes to the investors. So saying that, first and foremost, yes, your due diligence has to be in place, because that is a precondition for you to get the funding. Next, how do you value more? And then when you do the valuation, you say, okay, this is the valuation that I've arrived at, and then tell the investor saying that, okay, in the market right now, the EBITDA multiple is, let's say, 8x. And with my IP-based product, then my EBITDA is like 15x, 20x, or whatever be the number. So that differentiation you need to convince the investors. Investors always will break you down, but yes, then you need to stand up and then have a kind of do your homework, and then kind of negotiate with the investors for a better deal.
Sure. Thanks, Dr. Jacob. Those are very valuable comments on both the topics. I now, we are out of time on this, but we now need to move on to the next speaker. I welcome Dr. Gautam Bhattacharya. He is a partner at KNS Partners. And Dr. Bhattacharya, are you there? Do we have you?
Sorry.
Yeah.
Yes.
So, yeah, thank you for this. Now we are going to be speaking on global IP prosecution strategies. Now, this is from the previous two speakers. This is a further progression into saying, if you're a more mature startup, what should your global IP prosecution strategy be? Now, the previous speaker did mention that IP prosecution starts at home before you venture overseas. But generally, in your experience, what would be the global prosecution strategy for startups?
Thank you, Chetan, and a very good morning to all of you. And also thank you, ASSOCHAM, for taking KNS Partner on board. Now, what we'll do, we'll look at this question from 3 angles. First question is why global prosecution? Then second, countries of interest and the selection process. And if you have to go global, then how do you select countries? And third one is the last, cost optimization. Now, why global prosecution? There are a couple of pointers we should keep it in mind. First one is, if there is a chance that you or your competitor might exploit the technology in another country, you should consider filing in that country or region of the world. Provided, of course, you should have resources to file in multiple jurisdictions. Second one is ease of design around the invention. So now, if your competitors are active around some of those regions and your invention is easy to design around, then it becomes more important for a global prosecution strategy. And third one is, if you intend to increase the valuation of the company, as Mr. Jacob mentioned, that there are various methods and literally foreign a very strong protection overseas. Uh, it increases the valuation. It has a very big impact in the numbers. Having said so, we must also ensure that your IP strategy and business strategy are in sync, and your global IP portfolio's potential return. So whatever you expect, in other words, on the investment must be significant enough to offset the cost involved. As you know, in global prosecution, the cost is very high as compared to the Indian prosecution. So now, second, we are moving to the next question. Is the countries of your interest? Next angle of our discussion. So there are 5-6 parameters that should be kept in mind while selecting the countries, like place or places where invention will be manufactured or used. For example, you have developed a rice variety. Certainly, you're not going to file in Japan. Or if you have developed some fantastic electronics uh, item, so that you're not going to go and do a protect in Africa. So every country has their a specific manufacturing hub and specialized in particular kind of product or process. So therefore, where you are going to manufacture and use is the first. Second, your competition. Where would you and your competitors sell, manufacture, distribute, or import or export? So, and also where they file. So we also keep that in mind. Third point is market for the invention. How large and where it is located. So we need to conduct a thorough market research before we take a call on the market. Next is very important, which is that is there a geographic area or region that is most critical for if you look at from the strategic point of view, USA and Europe are strategic countries from investment point of view, as well as the when you leverage your IP. So it may also happen. I'll give you another scenario. Suppose you want to go and file in Europe, but your country or countries of your interest, maybe your market is in UK or Germany. So certainly your strategy should be not to go to entire Europe, but only in UK and Germany, thereby in fact reducing the cost of prosecution as well. Then another point comes to my mind is what is each country's potential market share, expected commercial viability of the invention, or size of the and most important is the size of your patenting budget. So how much you have or IP budget rather I say. One thing I would like to mention here is don't consider IP as an operational cost. Please consider this thing as an your investment. So when you go global, then you should be ready to incur expenses, and that you should be able to leverage the IP. Otherwise, there is no point. So now last point I would like to emphasize on the cost efficient prosecution strategy. So cost efficient, the basic and the fundamental is the drafting. Why I'm saying drafting, because sometimes or at times scope of the claims we keep it so broad, and we keep it a wide coverage that uh, it results in multiple examination. And you know, in overseas each examination costs a lot, so you need to strike a balance between what is your invention and how much you would like to what kind of scope you would like to have based on the invention and the experimental data that you have. So
Sure.
once you have
But Dr. Bhattacharya, if I may just interrupt you there. So how many countries, which are the typical countries that startups look at when you're advising them? And also, what are the typical costs that are involved, and how can sort of startups look at optimizing their costs?
So honestly speaking, it all depends on their business strategy. Sometimes uh, if your business, your market is in Singapore, so therefore you would go for Singapore if there is a particular kind of virus in some plants, and that particular virus is very prevalent in only Asian countries. Then there is no point in going to US and Europe. because in the as a temperate country, this we don't face this menace of the virus. So it all depends on the 5-6 points that I have mentioned: your competitor, your market, where the invention will be manufactured. So if you have a plan to set up a plant in Thailand, then certainly you should have. So as normally what I have seen as the other part of your question, that most of the startup they file in US, Europe, that, and then third would be the based on where they are going to manufacture, where they are going to where there are competitor based out of. So US and Europe from the strategic point of view, US certainly yes, Europe if they have budget, and third and maybe along with US wherever wherever they are going to manufacture or their competitors are based out of. And next question you asked about the cost. Cost also varies, which I'll come in my next pointers. So where I can add this component. So second, be aware of the country specific law and draft and prosecute accordingly. Exploit all government schemes. For example, India, there are several schemes, but in USA, you can also have several schemes like micro entity, small entity, where the cost goes down heavily. And here I'll talk about the cost, leveraging PCT and Paris Convention route. So there are several treaties across the globe. There is patent prosecution highway. If we can efficiently utilize patent prosecution highway, then we can reduce the prosecution cost substantially. Now coming back to the cost, average it would be in, for example, in US it would cost about 5 lakhs of rupees for the entire life cycle of the prosecution before the till the grant. Europe a little more costly, about 6-7 lakhs, because the official fee is very high. If you go to other countries like Asian countries, that would be about 1.5, around approximate figure I'm saying. Again, if you can invoke the patent prosecution highway, then you can certainly reduce these costs substantially. Yes, Chetan, I
Thank you,
hope that.
Doctor. I think that was, yes, I think that was a good overview about global IP strategies. But as we mentioned earlier, I think the strategy should begin at home. And the cost of prosecuting in India for our startups is substantially much lesser. And also it's more effective than sort of like initially venturing out globally. At this point in time, I also want to welcome Dr. Ajay Kumar Garg. He's just joined us. He's a senior director with METI, Government of India. Dr. Garg, welcome. Good to have you on board. You may be on mute, Doctor, but you may be on mute, Doctor. So maybe. So we may not be able to hear you. We are not able to hear you. Thanks. Thank you for that, Doctor. I think I will come back to you on your comments. At this point in at this time, I want to welcome Sri Nishad Natkarni, who is a partner at Ketan and Company. Nishad, are you there?
Yeah, hi. Am I audible now?
Yes, you are. Thanks so much, Nishad, for joining. So you have, we've heard various speakers speak about IP protection strategies till now, and you have a very important topic to cover, which is on IP enforcement, correct? So protection is one aspect, the enforcement part is another. So typically, and this is a difficult question to ask because there's a generalized term startup, but typically, how can startups both protect as well as enforce their IP, and with the emphasis on enforcement?
Yeah. I've seen the questions on the screen. I'll deal with the second question very quickly first. Very good afternoon to all of you all attending today. Thank you very much for ASSOCHAM for getting Khaitan and company on board. Well, Khaitan and company is more than happy to kind of respond to these things. As I said, let me just quickly address the second question first. How can startups protect IP generated by their employees and contractors? Now, as the previous speaker spoke, there are three kinds of intellectual property which are most important in the context of any organization. They would be trademarks, which would be identifying the source of the product or the service that you get to the market. Copyrights, broad domain. It could be your advertising material, your labels which you apply on your products. Your actual product may have copyrights, that may be music, etc. Then you have patents, which are products which have utility and which you get into the market, right? Now, when you're talking about employees, Copyrights Act has a specific provision whereby anything which is created by the employee in the course of employment would vest in the employer. Whereas for designs and patents, you don't have that kind of a provision, unlike in the UK where you do have a similar provision. So whenever you have having any agreements with your employees, make sure that irrespective of whether they are going to be generating copyrightable work or patentable inventions or designs, incorporate clauses in the agreements which talk about specific assignment of anything that they create and such that it vests with the okay. That's the first aspect. The second aspect is when you're looking at outside contractors, where you are retaining people to create any intellectual property, the concept which you would have known generally as work for hire, which means if you paid for it, it belongs to you. That is not applicable in the Indian context. So therefore, even with any external contractor which you retain for the purposes of creating your IP, you must have robust assignment clauses whereby all IP vests with you. There are specific provisions or requirements under the statute which require specific things to be mentioned in these deeds of assignment. A, you must mention that the territory is for the entire world. B, you must mention that the tenure of the assignment is for the entire term of the intellectual property and that it is perpetual. In copyrights, there is a specific term which says that if the assignee, which is the acquirer of property, does not exercise those rights within 1 year, then it will revert to the creator. Now, in copyright terminology, the author is the first owner unless he is an employee or certain situations. And therefore, you must essentially take care of this reversionary right also and mention clauses which deal with this. That is the groundwork with regard to employees and contractors. The second important thing is you must have very robust IP policies within the organization which help the employees understand the manner in which they are going to be creating IP. When they are using third-party content which is available in the public domain, ensure that it is really free to use and you're not infringing upon someone else's IP. Okay, so what you create is really original and belongs to you. That's the first part. The second part is there is often an overlap between types of intellectual property, and therefore you must be very careful that you apply for all forms of intellectual property that may subsist in a particular kind of work which is generated. Now coming to the second or the first question, if I may say, how can startups protect and enforce their IP? As Chetan said, 10 minutes are very brief a time to kind of deal with this very broad topic and is a huge responsibility. And I'm grateful for my earlier speakers to have touched upon some aspects of it. The first thing is that before you seek any protection or register IP, seek a holistic advice, A, and seek long-term advice. Don't look short-term. Look at what you're going to be doing in the long term, where you're going to be having your markets in the long term, and devise your strategies for protection accordingly. Seek advice not only on IP laws, but seek advice on structuring your IP. Should the promoter hold the IP? Is a venture capitalist at the time that he's going to come? Look at who is owning the IP. Is it the entity? Is it the owner? Is the entity the owner? Is the promoter the owner? Structuring of the IP, if the promoter is holding it, do you have proper licenses to the entity which is actually carrying on business? Are there any tax implications? Therefore, choose your advisors also very carefully so that you are effectively building your asset. Now coming to specific forms of intellectual property, When you're looking at trademarks, you may have logos, you may have composite marks. Ensure that each of these composite mark elements may themselves have trademark value. So apply for each of those elements. Identify each of your products and services and apply for registration in each of those product categories, because trademarks have 45 classes. Identify your classes. When you're doing your patents, ensure that your claims are very perfectly identified, because your claims define your invention. Now, because I said that you have to look at it from a long-term perspective, from the perspective of your market, etc., from a perspective of enforcement, there are certain peculiar things. Specific jurisdictions have specific laws, and therefore you have to bear those in mind whilst looking at protection as well as enforcement. To give you an example, India, in the context of trademarks, is a first to use jurisdiction, which means that if you have adopted a mark and started using it today, the rights accrue to you immediately. So the first to use the mark normally is the first owner of the mark. In the United States, however, a first to register policy is used, and therefore, irrespective of your use, maybe a registration may prevail over use. There are, of course, nuances, but I'm not getting into those in too much detail. Therefore, when you are applying for your trademarks also, ensure that you evaluate all of these aspects whilst not only applying in India, but also going to other jurisdictions and making your registration in certain jurisdictions if they have a, say, first to register policy. Okay. Now, in the context of enforcement, there are various aspects where you may face problems. When you're looking at trademarks, what are the elements? It is not only about using the mark on your product and telling the consumer this product comes from me. Trademark has various elements. Your corporate name, Tata Limited. Tata, the essential distinctive part itself is the trademark. So apply for registration for your corporate name. You may have other entities wanting to use the same corporate name, Tata XYZ Limited maybe, right? So that is one kind of problem in enforcement. The other is you have developed a good amount of reputation and goodwill in the market. Therefore, people will be trying to copy the mark, bring counterfeits into the market. There may be domain names which may be used, which replicate your well-known marks. So you have to keep watch on all of these. There may be people who have applied for registration for similar marks. Keep a watch for those. So what is it that you need to do? So in the trademark context, the value in a trademark is the goodwill and reputation generated by first using it and continuing to use it in an uninterrupted manner. So whenever you are seeking to enforce your marks, it is very important, A, to have a document to show when you started using the mark in respect of the product in respect of which you are enforcing the mark, and on a year-on-year basis, identify the material to show that you have in fact generated goodwill and reputation in the market. In terms of patents, ensure that your claims are perfectly and not too broad, not too narrow. Look at jurisdictions abroad so that when you are going under the PCT route, for example, your claims cannot be very different from what you've done in the originator country. So take holistic advice in that context. Now, the other aspect from the context of enforcement is that there are exports, there are imports, those also may be issues in the context of counterfeiters. There are border protection measures. You can apply for registration of your works with the customs authorities and they may block import of infringing products. Now, what is the nature of the actions that you can initiate? Very important thing that you need to remember is in the context of trademarks and copyrights, you have both civil and criminal actions available to you. In the context of patents and designs, only civil actions are available to you. Now, what are the differences? What are the differences between the two? A civil action, you can obtain an interlocutory relief in the form of an injunction. What is an injunction? You are stopping a third party from utilizing or exploiting your intellectual property, be it a trademark, be it a copyright, be it a design or a patent, right? The second relief, which is very important, is in the context of counterfeits, you can seek a search and seizure order, which means that you can get an order to go to the premises of infringers and seize the infringing products which are violating your intellectual property. And the third and most important aspect, which normally comes at the end of the proceeding, is your claim in damages or the monetary claim. Now, in a civil action, all of these three are possible. Whereas in a criminal action, it is normally of a more deterrent nature, and it is normally limited to penalties, imprisonment, and search and seizure. You must weigh your pros and cons before initiating a particular kind of proceeding versus another. And of course, the nature of the reliefs, the nature of the proceedings that you wish to initiate would depend upon
I think Nishad,
the nature of the violation.
Yeah, I think those are very valuable comments. Unfortunately, we are a little bit out of time, but
Yeah,
I think those
that's
enforcement
about it.
strategies are quite relevant. I also want to inform the speakers that there are literally hundreds of questions which are flowing in. It may
For
also
sure.
not be possible to answer all of them. I've selected a few and assigned to each of the speakers. If we have time at the end of the session, we can take a look at that. But at this point in time, I wanted to invite Shri Tarvinder Singh, and thank you, Nishad, for that insightful session. And Shri Tarvinder Singh now is a senior partner at Kochar & Co. Dr. Singh, are you there?
Yes, sir, I'm there.
Thank you so much. So I think your topic is on what are the timelines for registration of various types of IP. And generally, if you can also elaborate on what are the procedures involved for registering this various kinds of IP, that would be very helpful. I think there are a lot of questions, in the list which I have received, which talk about what are the timelines, what are the procedures. The procedures are too cumbersome. We cannot understand this. So if you can just summarize that, that'll be really helpful for most startups.
Well, thank you, Chetan, and thank you, ASSOCHAM, for organizing this show, this program. Well, all the honorable previous speakers have thrown light on this very important topic, which is intellectual property in the life cycle of a startup. The topic itself is inherently clear. A startup which is just going on its legs in today's digitized global village, and therefore, needless to say how important the intellectual property is. Actually, I have ceased to call the IP as intellectual property. I feel that it should be industrial property, in the true sense of the term. But be that as it may, for timings, I would like to start to say that all the mainstream codified intellectual property legislations, which is Trademarks Act, Patents Act, Copyright Law, Designs Act, and of course GIs, they gave timelines for various events in the life of an application. For trademarks, for example, as previous speakers have said, that first to use in India is also gaining critical mass on its shoulders so far as trademark rights acquisition is concerned. On the statutory front, the trademark filing is quite simple in nature. It's not cumbersome at all. You can do it online, you can do it offline. One needs to just fill a form and mention a few details about who is the owner of the proposed trademark. Are you using it prior to filing the application? If yes, since when? And then, of course, the other administrative details of addresses. Is there a single owner, joint owner, etc., etc. So filing a trademark application is fairly straightforward now. The more you use the mark prior to using the filing the application, the better are the chances that you will be given a registration. As I said,
Dr.
trademarks
Singh,
and
if I sorry to interrupt you, but one of the frequently asked questions, given the gig economy which is now operating
right.
across India, is I'm running a website, I'm running a blog. Can the content on that be protected? How do I go about protecting it? So if you'll also answer this question, it'll be very helpful.
Sure, sure, Chetan. Well, essentially, the content of a website and a blogs come under the umbrella of copyright law, so which of course can be protected under the specific category of work, quote unquote, of the Copyrights Act, whether it's a literary work or an artistic work, and so on. So, for timing, let me come back to the word timing. There are timings prescribed under the trademarks law as to if you're claiming a convention application rights, then Paris Convention rights, then the window available to you is 6 months from the date of a foreign filing, and then you file it in India. This is the first milestone so far as timing is concerned. Then the application is examined. The examination report needs to be answered within a specific time, let's say 1 month, which can be of course extended. And once you file the response to the official action, if any, the registrar may accept the mark for publication or may appoint a hearing. I'm not talking about practical delays and because of the overload on the grid of trademarks, but there are internal timings given by the statute. Then you have, after the publication, people can oppose your registration with a window of 3 months or so, etc., etc. Similarly, when you file a patent application, if you are filing with the convention priority of a foreign application, you have a window of an year to file it in India. The clock will be moved back, literally speaking, to the date of filing in the foreign jurisdiction. You have important, very important timelines given in the Patents Act, which is essentially very time sensitive. For example, filing a response to the examination report within 6 months plus 3 months, which is 9 months. Beyond that, if you don't do that, your application will go dead. If you don't request for an examination of a patent application within a specified time frame of 48 months on the date of filing, your application will be dead irretrievably. So similarly, there are timelines in the Designs Act, nothing much in the copyright law. Now, the timings taken by the intellectual property authorities, granting authorities, which are trademark registry, patent office, designs registry, copyright board, etc. Well, that's an area which is of concern still to the Indian filers, because especially in the trademarks and patents, there's a lot of time taken by the authorities to accept, reject, grant patents, trademarks. There are delays in opposition proceedings, and usually the reason is that there is too much of load on the trademark registrars and the other staff. There are too many things to handle in a very large country like India. And of course, to an extent, they are absolutely right also. I think we should hire more examiners and controller, but that's a separate cause of action, not for today. So timings from the priority context, priority claiming context, and timings given by the statute is very important. All the startup executives should keep that pinned up in front of them on their workstations when they are strategizing to adopt a brand, or if they are getting into co-branding, if they are filing a patent application, which markets are important, what are their timelines, because most of the jurisdictions, let's say Japan, US, UK, Europe, their usual time taken to grant a full patent is between, I think, under 3 years. I don't know whether if I'm wrong or correct, but my experience says that 3 years is what US, Japan, Europe take to grant a patent. So they have to keep a tab on these timelines abroad so that they are not lagging behind their marketing strategies, approval strategies, and so on and so forth. For a
Dr.
startup,
Singh, so once again, one of the other questions which keeps coming up in the context of startups is, what happens to, what are the timelines for registering domains and any enforcement on domains and things like that? In your experience, typically if there is a, if there's a domain and there is a trademark challenge on that, or whatever the case may be, how long does it take to sort of like resolve some of these things? This is also a very frequently asked question.
that's right. Domains and trademarks, of course. Okay, let me just answer this question of yours from a different perspective. To put it very simply, one can get a trademark registered in India, whether used or not. Straightforward case, not many complications in terms of statute, not very common words, generic words which have been applied for. You get a trademark registered in your name in, let's say, under 3 years in India, if there are no oppositions. Patents which take a little longer, you may get a patent in your name, granted in your name, in less than, let's say, 4 years in a straightforward case. Okay, now let me come back to domains. If there is a domain snatch, for example, let's say I prosecuted a case for Emirates. Somebody took a domain name called emirates.co.in. There's a very well established domain name dispute resolution policy in India, under the domain name registry in India, which is pretty quick, like the foreign jurisdictions. You get a decision in, I think, 3 months or even earlier than that, and the decision is binding on both the parties. If the other party is sitting on your domain illegally, they get evicted. Trademarks, domain, there's a lot of correlation between them. Domains are trademarks also. The startups, the most important point which I want to make today is, which is of course a little problematic also. India is a common law jurisdiction. Akhilesh is there, who can dwell upon this a little more, and others. It's a huge country of 130 crore people. You have this common law system which says use it or lose it. Plus, a guy who's using the trademark or a domain, he has more rights than a guy who's got a registered trademark but not using it. So my advice to startups is keep an ear on the ground. A previous speaker, I think Aparna, talked about keeping your ears on the ground in terms of taking a look at your portfolio. Is somebody infringing it? Get a search done, hire a private investigator to see if similar goods are being traded on or being sold under your brand name or a similar brand name. Similarly, patents are being violated, etc., etc. Just you need to be aware. Send cease and desist notices, especially for startups. Be aggressive on the front foot all the time. Send notices to people who are treading on their who are trespassing, maybe unintentionally. Go and tell them that this is not your territory, and so on. So there are important questions on domains and trademarks, which will depend upon case to case. But of course, there are certain overlapping territories that the startups need to be very careful about.
Understood. Thank you, Doctor. Thank you, Mr. Singh, for that insightful conversation, and especially on domains. It's in fact a very frequently asked question amongst the audience. Now, just to move on to the next speaker, and this, we welcome Shuchi. She's the founder and managing partner of IP Niti. And Shuchi, are you on? Can you hear us? Good afternoon. So I think there's a little bit of disturbance on your line. Maybe that needs to be cleared up. But I think you have a very important topic, and there are a lot of questions around protecting software. So without, let's just jump into the first question. So you have a lot of technology startups online, and they are very interested in saying, how can we protect our code and how do we protect any inventions, which they embed their code in? So can you answer this question first?
Sure, absolutely. I do that. But before I do that, I just want to check, is it better in my audible?
No, I think you need to disconnect your, your earphones. Maybe directly speak into the computer's mic.
Okay, is this any better?
Hopefully, yeah, but continue, please.
Or I can just switch off my webcam. I think that will just play with the bandwidth. Okay, so
Continue,
does this
Shashi.
seem
Yeah.
okay? So it's a pleasure to be on part of the panel of esteemed speakers. I thank ASSOCHAM for giving us this opportunity as well. I think no better way to decide or to define that software plays a very key role in our life. So we are all going through pandemic times, and had it not been for software, we will not connect today. There is no possibility of this webinar that we are having. So if you actually look at it, we all understand the importance of software, and software is not even as a separate segment of the industry, which is so defined in terms of IT sector or computer engineering. If you look at the mix today, whichever field we talk about, whether we talk about robotics, we talk about everywhere you see that there is some role that it is playing. And largely, one of the reasons why I would say that it's very different technologically as compared to other technologies would be if I talk about mechanical, I know we are talking about machines. If I talk about any other field like pharmaceuticals, we know we are talking about drug formulations. But the moment you talk about software, you are talking about the number of facets, and you have to see whether each facet is properly protected or not. And this is exactly where the challenge comes, because really we cannot talk about a single form of IP, which was very beautifully described by the panelists earlier. There is no single form of IP that completely protects software. So it's important to possibly bear a couple of minutes in understanding what these different facets are and what we can protect under which regime of IP or which instrument of IP. So broadly, if I talk about, when you talk about software, one thing that stands out is that you obviously have a code that you're writing, which captures the functionality or the algorithm that you would like to talk about, which defines how your computer program will function. So when I talk about the source code, I am basically saying that I'm writing my algorithm in a particular programming language that could be any, for example, C++, Java, or these. That is something that needs to be protected. Second, when I talk about, and you can also have a good consideration of that, is how my application would have an interface that would be displayed across the screens. So we are talking about user interfaces, and actually the very, very innovative interfaces which are coming, which require a lot of work by the person who has created the same. So that is the second thing that needs to be explored and protected. The third thing that we talk about is the function that the software is going to achieve, which is generally called about as the functionality of the software which needs to be protected, and what is the regime that you can go ahead and protect. Having said the three facets which are important to be protected, I'll talk about one by one under what instrument of IPR can you go ahead and protect those. So talking about the first two, which is your source code and your user interface, specifically if I talk about in India, you can use copyright as a mechanism to protect the same. So as long as your code is original, where it is being created by the author as an outcome of their intellectual effort and creativity, the source code as well as the object code can be protected under copyright regime. The user interface in India, there is no clear-cut distinction. I would say that there is a separate regime under which you can seek protection, but it is largely protected as part of your source code under copyrights. But if I talk about this, so we have had numerous cases where we've been able to protect the user interfaces in US under the Design Act of the US. So this also would vary depending upon which country you are delving in as to what protection will be accorded under which instrument. Then the third one, which was the functionality part, is something which is more broader in application and should be protected under patents. Now, when I talk about patents and what really would be the difference in terms of protection between patents versus copyrights, just in a brief, if I have to talk about. So the moment you talk about protection under copyright, the entire code that you've written, in the programming language that you have written, is protected. But if somebody else comes and codes the entire thing in a different programming language, then you do not have a copyright protection for the same. But if I talk about patents which largely protect functionality, anyone who is copying the functional character or the means that you have achieved by way of the software is what the copyright rights for. And these are fairly broad rights in terms of the protection, but yes, there is a challenge as to whether you can get a patent granted or not. And my co-panelists have delved upon the subject to some extent. In India, there is a challenge in getting software program patented, and largely there is a statutory section in the law, Section 3K, which says computer per se cannot be patented. So, does that mean that every software that we're talking about cannot be protected? The simple answer is no, that's not correct. Largely, I would go ahead and divide software into categories to elaborate what kind of software can be protected by you versus what cannot be protected. Any software which is largely a data processing mechanism would be hard to get a protection under the Indian law. As an example, let's say I have a website which basically is used to find the ratings of a particular product, and what that does essentially is you have crawlers, they go across and they collect the feedback about that product from different websites, and at the end they give you a percentage about whether this product is good or bad. So this largely is categorized as a data processing mechanism and may not be patented in India. But if I talk about another software where let's say we have an adapter for charging the battery, and you have the same adapter, the same hardware which is available, and merely by changing the software, you end up charging the entire team in fraction of the time that you used before. So this essentially means that there was a difference that your software needs to the underlying hardware, and such things are certainly protected under the Indian law as well. If I talk about now from the perspective, is there any other IP statute available? In a sense, the moment I say Windows or I say Mac, what this rings a bell is we immediately know that we are talking about an operating system. I don't really have to say that I'm talking about a software which is meant to operate a machine, which means that every software has a particular name or a brand that it carries with itself so that people recognize what is being talked about. So while this is not the functional part, the trademarks are something which you can use to protect the brands that you use for your own software. And last is the trade secret part. The trade secret is basically, I would say there is always a contention whether you go for a patent or a trade secret. And I genuinely will advise you that you should seek proper opinion, a legal opinion as to which one is better for you. Generally, a trade secret is something that you keep secret with yourself and you do not file for any kind of rights. This remains a secret as long as it is not leaked in public, which means that if somebody else happens to invent or come across the same software or concept, then you would have no protection left because independent creation cannot be used as an infringement. But if you think reverse engineering of your software is not possible, then certainly trade secret is the way to go and not patent. So
I think Shuchi, I think you've covered some of these aspects on your talk. Unfortunately, a lot of your audio was inaudible to the audience, but towards the end, I think it became better. To recap, there are possibilities in protecting software. You also have to keep in mind, some of the other IP aspects such as trademarks and whether a patent is necessary or whether a trade secret. Or whether it should be kept as a trade secret. So, we have run out of time on this topic. And thank you so much, Shuchi. And perhaps we can, I'll circulate back the questions that a lot of the, participants have asked. Now, moving on. Finally, we have Dr. Ajay Kumar Garg. I request him to provide the guest of honor. He is the Senior Director at the Ministry of Electronics and Information Technology, Government of India. Dr. Garg, are you on?
Yeah, I'm on. Are you able to hear me?
Yes, we can hear you. Over to you, Dr. Garg.
Yeah, thank you, ASSOCHAM. Thank you for conducting such a relevant masterclass at this very important juncture of the economic uh, change that is happening in the globally and India in particular. And I must also compliment you that you have got the most eminent of the experts on the subject who have spoken. I had the privilege of hearing them for the last half an hour to 45 minutes, and I've been educated a lot. And I hope the startups have also gained a lot of experience from their expertise. So, thank you, all the experts, for giving those insights. And I hope that the startups will continue getting such support either through ASSOCHAM or from them directly in their journey towards promoting innovation-led economic revival of India post COVID. I'm no expert on topping and specific issues of managing IP and not, but I'll give you a broad perspective and try to wrap up the things. How do I see IP in the present scenario? So in the present scenario, the post-COVID, one thing is coming out very clear that the digital technologies and in technology in particular will have a great deeper role in the economic revival, and countries which are in the forefront of technology will be the fastest to revive in the present pandemic situation. Having said that, it's also important that which country has the capacity to do it and what should be the strategy that to go forward in this. In terms of the capacity, I think India, because of the huge talent pool that India has on technology, thanks to the very robust educational system that we had for the last 70 years or so, thanks to the great role which the Indian IT services industry played, where technology became the forefront of India's economic growth. And of late, in the last 8-10 years, the emergence of a very, very robust startup ecosystem has all been important and will play a very critical role in the coming years, where technology will be the most key enabler for the global economic revival. We might see a short-term downturn, but India has an advantage in this aspect, because what I see in my interaction with the startups, that we have been able to generate a lot of excellent ideas converted into possible business scenarios in the last so many years. And we actually, the startup ecosystem had started maturing from a pure plug and play facilities of e-commerce websites and others. Now they are moving into very detailed situations. We are solving problems of the world which no one else has the capacity to do that, for two reasons. We have the talent to solve problems. Second, and most obvious, is that we have the problems which the rest of the world doesn't have. So we are sitting at a very advantageous situation right now, and it's up to us to decide how do we go forward. In this aspect, it is important that in going forward in this journey, there are two important aspects that are there: monetization of the ideas, monetization of the ecosystem around it. Second, creating an environment of open innovation, but along with a monetization ecosystem. So the balance in the IP world is a very important parameter that will be there. And thanks to the whole ethos of India's journey till date, the way the Indian IP policy has been drafted, the way the government of India has been giving an whole array of support, whether through the Startup India program, where they have given a substantive subsidy to the startups in terms of filing domestic patent, or MIT's policy on the CPIT, where we actually encourage our startups to take their patents global. So all these schemes of Government of India along with many of the incentives that the state governments are giving, India is at an advantage with regards to startups converting their ideas, their inventions into monetizable IPs in forms of patents, trademarks, or copyright. At the same time, what we have also done is through created a lot of robust open innovation networks, and our journey on digital with regard to public digital platforms where a public private partnership becomes a key enabler for technologies to grow and grow at a speed which is unprecedented, grow at numbers which is unprecedented, is a clear example where a right balance between open innovation and monetizable IP has been created. A clear example is the way the UPI has enabled an equal playing platform for many of the mobile wallets, and there is no monopolistic games that have been played. So India has been able to create a right ecosystem in terms of a balance between a strong IP regime, a regime which is actually, I see the CG is there, and so he will talk about the sea change that the Indian IP system has created. But what my personal experience is that there has been a lot of progress that has been done in the Indian IP system in the last few years, and we are here to be globally competitive on that aspect. And also on an open innovation system also, we have actually taken a journey which is very different from the world. And right now we are sitting at an advantage with regards to creating innovation into an economic opportunity for them. The important thing is this, that how do we actually support the growing tech ecosystem and continuously support for them to become large players. Three things are important. One, the capital. Second, the market. And third is the management, so that the right entities, may be it non-IP management or IP management, which is required for these players to become competitive and are not and are not killed by the large corporates that exist in the country. The role of the corporates has also been very encouraging in supporting the startup ecosystem, and I think that we are on the right journey, and we need all the support of the industry, the support of the IP experts in taking this journey forward. Thank you once more for giving me this opportunity to speak.
Dr. Garg, thank you for those insightful comments. Very quickly, two questions. One on, do you feel, now there's a personal data protection bill which has been there in Parliament and is before the committee. So data privacy and protection is very critical. Do you see any movement on that very soon? Because along with IP, that is very critical. And number two, in terms of the national IP policy, there was a news report saying that IP can be monetized, for instance, by mortgaging that with banks and things like that. So is there any movement towards that, or is there any, anything to that extent which has been thought about by the government?
Too quickly, on the data protection bill, yes, India is among the top first 10 countries to come up with a comprehensive privacy bill around data, which is very important if we think that data is the future enabler of all innovation and all economic growth that will happen, or as many people call data as the new oil. So we have the PDP bill drafted by the expert committee, now property of the parliament, and I hope, given the given the present situation, it has been delayed by a few months because the parliament has not been able to function at a speed which it normally does. But I think as soon as the parliament meets, this bill will move forward. But right now it has gone out of the hands of the executive. It's a property of the parliament, and we do not have much to say on this aspect right now on this subject. As regards to using IP as a collateral, the laws are in place to allow IP as a collateral for getting credits. banks have been instructed to view this also as an instrument while giving credit. And recent changes in the MSME rules with regard to waiver of collaterals is in the right direction, and I think the funding mechanism, the credit systems for startups is being deeply looked at by the government. We are coming up with a software product development fund of 25,000 crores for the startup, and we think that the government, along with the corporates, will move towards greater flow of rupee capital into the startup or the innovation ecosystem. Thank you.
Thank you for that, Dr. Garg. I now invite Shri O.P. Gupta. He is the Controller General of Patents, Designs and Trademarks, Government of India. Gupta ji, thank you so much for being on the panel, and over to you for your chief guest address.
Thank you, Chetan. Good afternoon, everybody. Good afternoon, my fellow panelists. I hope everybody is able to hear me.
Yes, we can hear you.
Yeah. So first of all, I'd like to compliment ASSOCHAM for organizing this webinar, because the topic which we have chosen is really relevant. And when you use the word masterclass for startups in IP, it actually makes it a little more relevant, because in times like this, startups have a major role, and IP is an area where, especially in India, startups are still, getting used to it. When I see the topics which have been discussed by various panelists and experts, I am really happy that the total domain which has been covered, whether it was what is IP, to IP strategy of a individual startup, to startup funding, to international procedures, and your global IP practices, or even timelines, and expert address by Dr. Garg. So the gamut of topics which you people have covered really give, I'm sure, a real lesson to most of the startups who probably have have been attending this particular class. I would like to just emphasize on a few specific points which I have kind of noted from discussions which have taken place till now. When we start talking about startups and IP, the word startup itself talk about something new, and something new can come up from a new idea, new technology, something new thing. So in my opinion, IP becomes an inherent component of a startup, because if you are just doing another activity which is already in public domain or public thing, then you are just following in the footsteps. But when you say my startup, means you are starting afresh, and that has to start from a new idea, new product, new technology, something. And inherently, as was defined in IP, that intellectual property comes in play. Now, what Government of India understood this aspect very much, and under Startup India program, very specific focus was given to protection and follow-up action on intellectual property to be created or being created by the startups. And when we start looking back 3 years back, 2016-17, I had the numbers, only 180 patent applications were filed by the startups in India at that point of time, in year 2016-17. When I see those numbers growing up to around 1800 in the year 1920, which have just concluded, I'm at least happy to note that there has been significant progress in that direction. It may not still be to the extent where we see that number of startups which are getting registered, and the number of IP applications still coming up is probably not still commensurate. When you think of trademark applications also almost around 110 applications in 2016-17. They have touched around 3,000 plus in the year 1920. Now, trademark will be the first point of entry probably for a lot more startups, because trademark gives you the identity. As a startup, whatever you start with, probably you will go for the trademark first, and then of course other aspects of IPs will get in. When we think about the specific benefits which are being given to startups under Startup India program or under the SIPP scheme, which the government of India has rolled out for startups. So first major benefit we have given to startups is the filing fees. Now filing fees for startups have been put at par with individuals, which are almost just around 20% of the one which is applicable to corporate entities. So that is a big, first big benefit which was given immediately. And then of course, when we started interacting, the issue came up that startups do not have the wherewithals, the means and the expertise for filing, drafting and processing and prosecution of their IP applications. And therefore, the other part of the scheme was brought in, that where we now provided list of facilitators, and I see on the chat that somebody has already put that link where the whole list is available in patent, trademark, design, all those facilitator lists are available, where the government refund the fees for drafting, filing, drafting and filing of your applications in IP office, as well as subsequent prosecution with or without hearing. Now, this was the what we call economic benefit, which was given to startups. But the major aspect, very important benefit, which I would like to highlight here in today's, this class. Somebody was talking about, Mr. Tarvinder, if I remember, he was talking about timelines. And timelines was a major issue in India for sure. Like patent applications, I remember when I joined this office in 2015-16, the average timeline for an examination of a patent application was 72 months. 6 years was just the time for examination. Now, similar thing was there in trademark. For up to 3 years, we were taking, to register a trademark application. Examination itself was taking more than 13 months. But you come down to March 2020, and now your all trademark applications are getting examined within 30 days from the date of filing. We issue you a registered trademark certificate in less than 7 months, because 4 months is the statutory period where we have to keep your application in public domain for others to see and file objections if at all your trademark is similar to other marks. And therefore, those 4 months period, if you remove, then we just take around 2.5 months in our office to dispatch you your own trademark certificate. Now that is the timeline where number of years we were taking. Now we have reduced it to number of months, 3 years to less than 3 months time, which we take now registering a trademark application. Patent application, new patent applications are already getting examined now within around 18-20 months from date of filing in most technology fields. We still have some backlog in specific technology fields, but out of the technology fields which we have kind of divided our office 4 major groups and 14 sub technology fields, we now out of 14, around 11 technology fields, we are already examining applications filed in 2019. But for startups, we came up a very specific idea of expedited examination, and that was for startups themselves and for international applications where India is chosen as the international search authority. Now, when I was hearing for discussions regarding protection, global protection of startup applications. Now, how these two things are related? The number one, startups, Indian startup would like to file an application in India for 2 reasons. That one, of course, the cost. Somebody mentioned that cost in India is minuscule to the global costs of filing and prosecution, especially in patents. Of course, trademark is still cheaper across the world, but patent costs are very high in certain global jurisdictions. And second, your international applications, because as you know, the date of priority is taken from your first filing in the receiving office. Now, if you can file your application with international application in the receiving office within 12 months if you want to claim your original date of priority. So 2 places you can file your international application, one within the first receiving office or the international office Bureau of the WIPO. Now, within these 12 months, if you file an application and designate the jurisdictions where you would like to protect your invention, then you get up to 30 or 31 months to actually file a national phase application in that jurisdiction. So you really need not to spend monies to protect your invention now, until unless you are sure that your invention is good enough, commercially viable, and is good enough to replicate in those jurisdictions. So you get that kind of time, and if you file those applications in India, and then we give you expedited examination. And you'll be happy to know that most of the expedited examinations which have been for request for which have been filed in India, we have been able to give a final decision on those patent applications in almost less than a year in most applications from the date of your request. So, and you can file your application immediately, you can file your request for examination, and most of such applications for startups or expedited matters, we have been able to give a final decision within 1 year. And in fact, the shortest time where a startup patent was granted was around 140 days from the date of request of examination. Now, this is a major, facility which has been provided, because most of the jurisdictions, as was brought out, even in developed jurisdictions like Japan, US, Europe, you take between 24 to 36 months, depending on again your field, of invention. But India office can give you final decision within 12 months. You have opportunity to file your international application, and you have opportunity to then enter the national phase application in those jurisdictions where you feel your invention will be good, commercially viable, and will derive the economic benefits to not only you but to the whole country and society as well. So these are the three major aspects which in terms of facilities, in terms of economic benefit, and in terms of processing benefits we have given. Another point which I would like to emphasize, because most people who are participating are startups. When I have seen a lot of such matters where startups file an application and expect immediate decision, especially in trademark, this issue has come up, and that is regarding copying a mark. Because I do agree and I do accept here that only place where we are still having problem of pendency and timelines is the trademark opposition matters, because there the timelines are still, we are unable to, because these are all quasi-judicial matters to be heard. Both the parties, full court procedures are to be undertaken there, including filing of evidence and then cross supply of documents to each other, getting their replies, and getting matter to the hearing stage, and then of course hearings, which takes a much longer time and which cannot be processed electronically, because that is one aspect where even today we have to go for physical hearings where multiple parties and with their attorneys are to present themselves for hearing. Now, while filing a trademark application, I would advise all the startups that please have a look that similar marks are already pre-existing or pre-filed or under use, because somebody was very correct to point it out that in Indian law, trademark is first to use. Now, you may be first to file, but somebody must be using the trademark already somewhere in the country. Now, the moment you file an application, your application get published, and that person come across this mark, he or she can simply come and file an application saying, this mark I've been using for all these years, and they oppose. Now, that opposition matter will automatically then will get in the queue, and as I said, earliest pendency removal time in hearings I can think of is minimum 3 years. That is one point where I will still like to bring it to notice of all the startups, that please have a look at the originality of your trademark. As I emphasized in the beginning, that when you are starting a thing, it shall not be based on somebody else's ideas or somebody else's mark or somebody else's concepts. It really has to be original if you are looking forward to getting an IP on that. And that is one point, especially in trademarks. I have seen cases where people have been then following up these matters through RTIs, through public grievances, through mails to various government authorities, but I'm unable to help those people at all. And that is one aspect which I would like to again emphasize. And currently the database is available, systems are available, and hopefully within the next 3 months we would be giving you a very good search function in our new electronic trademark registry module, which hopefully we should be able to launch within this year. And that will provide you complete database to search all India trademarks, because jurisdiction is, even though Indian, but a lot of well-known trademark of outsiders, they are registered in India and they are protected in India. So you may say that this is not being used in India, but it's a global brand and globally recognized, well-known mark. Some such case has come relating to some battery matter, which I have personally seen. Now, these are the cases where the applicant may feel that they are not being given their due by registration of trademark by the office. But I'm again emphasizing that is one point where office will not be able to help you at all. And even if you really pursue this through court of law, the possibility of you getting relief is almost zero. Because
Gupta ji, on this point, which is very interesting. So if I wanted to ask you, so in terms of like appearances for any, for instance, a trademark infringement, so has the department thought of taking this entire process online? So given the COVID situation, there is not a lot of movement of people, and it becomes difficult. So is the department thinking of taking the entire process online? That is the one question. And the second question which I had is, given that the gig economy is becoming very large in India, it involves a lot of, for instance, video logging. It involves all of these, all of the gig economy, or what constitutes a lot of IP is being created, but a lot of the IP is also being transferred to various platforms that own that host this these new for instance video logging or any of these features. So has the department thought about how, for instance, individual contributors can be better protected, instead of what is currently happening is a complete transfer of all property to marketplaces or hosting providers overseas? So these are the two questions that I had.
Your first question regarding online, I don't know how many of actually, I'm sure lots of attorney firms which I have seen on the panel, and they must be using all this. Indian IP office is absolutely online. The processing from end to end, say trademark, from application filing till receipt of your registration certificate, it's all online process. You're not required to visit IP office at all until unless, as I said, you are required for a hearing, and that too only in opposition matters. Because show cause hearings also we can do on video conferencing, but opposition hearings are the only step in trademark where you are required to attend. Same applies for patent. Complete processing end to end, as I said, from filing till receipt of your certificate. It's purely online process. There's nothing where you're actually not required to visit IP offices at all. Now, second aspect, when you say transfer of IP, where it can be hosted and where, what kind of things can happen. You asked, in fact, Dr. Garg also the question whether IP can be taken as collaterals. In fact, if I remember correctly, IP as a collateral has been the concept in India for quite some time already. If you people remember Kingfisher, the Kingfisher brand was actually, given as a collateral under loan application, which is in ongoing litigation already in that particular loan default matter, where the brand was valued at. After that, what happened? If the brand has been valued, say, 2,000 crore at given point of time, and tomorrow that company just shut down or go bankrupt, the brand value comes to zero. And that's where the problem today people are facing in actually valuing the brand. The valuation becomes a difficult aspect for bankers and people who are giving loans, how much collateral one can take as a brand. Now, that is one aspect which, of course, has to be seen by the entrepreneurs themselves and the financiers as well as the bankers who finance these things. Regarding transfer, most of the IP, you have both the options. You can do outright transfer by assignment, or you can transfer your limited right by licensing. Now, it depends on the type of IP you have and the type of product you have. Where some of entrepreneurs may like to see serial entrepreneurs, they just simply say, okay, I initiate a business, I put it up to a certain level, it gets some commercial value, I sell it and get out of it and go for next venture. Now, those people may be doing assignment outright and just selling off their one enterprise and move for another enterprise. There may be somebody who may still think that there are further values in the existing enterprise, and then you start, okay, this is the first part, but you need money for this, so you start licensing those things, and then you continue your creation of IP in the same facility or same enterprise, and you keep growing it. Now, these are the options which are available. The law provides for them, and there's no problem. In fact, Indian law that way is probably both in patent and trademark and in design, one of the best drafted laws. Even a situation like COVID was taken care of by Indian law, as you must have seen. Lots of jurisdictions have started talking about compulsory licensing or appropriation of patents or not allowing patents to be granted for COVID technology at different point of time. But in India, our law already provides all these facilities to us. Depending on the technology and the use required to be done for the benefit of stakeholders and the public, we have the options of using either of those options, whether it is a compulsory licensing, whether use of technology for government purposes, or use of technology for other private entities, which then can be used only in public use for public purpose. So all these things are available within Indian law, and I'm sure the overall Indian IP system and scenario is now very much conducive to start moving towards the next phase. Because as I said, in patents and trademarks, both these places, we have now created enough capacities. By end of this year, that is December 2020, I can assure you most of the patent applications will start getting examined within 12 months from the date of RQ filing. And I'm talking about the regular applications, not the expedited ones. Expedited ones we anyway still do within 1 to 3 months, depending on field of technology. Trademark, as I said, we are already doing registration within that stipulated time. We may think of even reducing further, depending on stakeholders agreeing to cut down that 4-month period from 4 months to little less. So now we are at that stage where timelines in India would be for sure comparable and at times better than most larger jurisdictions in processing IP applications. We have already started PPH with Japan, which is already in process, already in operation. We have now started receiving PPH requests from other jurisdictions, depending on the mutuality and depending on the government's relations with those specific jurisdictions. We would certainly be now looking forward in that direction as well, where India has PPH with major offices across the world. And therefore, that would be the probably last gap in Indian IP regime being completely integrated with the global IP regime. And I see a very bright future, and I see that the speed of filing in patent as well as trademark, the way it is growing in our startup ecosystem, I'm really excited to see that in future these numbers will grow at a much larger pace, and we should be able to deliver them the requisite services to their satisfaction to further encourage them to file more and more IP applications in India. Thank you.
Thank you, Gupta ji, for that comprehensive overview, and also the roadmap for how it is going to be looking in as short as a few months' time. And that is all time that we have for today. Before I pass on the baton to Ashish ji for his closing remarks, I want to thank all of the participants, the speakers, and also the government for coming out and spending time on this masterclass. Thank you all for giving us an opportunity. Now, Ashish ji, over to you.
Thank you, Mr. Ketan. Thank you very much. I think all of you deserve a big round of applause. I think this is a great discussion, wonderful discussion. And after this discussion, after listening of this discussion, I can say that India has the best, robust system of the IP in the world in terms of timeline, in terms of costing, in terms of transparency. So if you see any aspect of the IP for the startup, so that's a great thing. And I think whatever the discussion which we had, really a great discussion from the point of view of the startup, from the point of view of global IP or domestic IP. I would like to thank you to the O.P. Gupta ji for his chief guest address. I think, sir, you have done very wonderful deliberation. It's icing on the cake, because you have given us the statistics about the filing, the number which was 100, in the range of 100, now it is in the range of 1,000. In spite of it, the kind of timelines you are making, timelines other than the transparency, then you have given the costing aspects also, that we are the lowest in the cost. So this is a wonderful thing, and we recognize your effort, because after you are joining in this department, you have done wonderful job, and in the future also you have given the how you are planning to go in the future also. It's really great. Thank you very much for joining with us and giving us the chief guest address. Now I'll come to Dr. Ajay Kumar Gargi. I think from the Ministry of Electronics and this technology, you have done this. This is a great remark and great deliberation as the guest of honor, and you have covered that this technology will play an important role in the future. I think it is playing an important role, and in future also it will play an important role. Then monetization of idea, that is a great, I think, aspect which you have given to us. Other than that, one thing which we have quoted, that streamlining of credit to the startup. I think this needs to be looked at, because you see, as of today, the startups are not getting banking lines because of collateral lacking. So this aspect yet to be taken up, and I think from the ASSOCHAM side, we will put this recommendation in our memorandum after this webinar. So thank you very much, Ajay again. And now I would like to thank you to all the panelists, each and every panelist, for their deliberation on various topics of the IP. I think everybody has covered in a big manner or in a different manner. You have shared your experience by example. If you see that you have covered that how to file the IPR, how to protect it, how to enforce it. So all, I think there are many topics which you have covered. Number of topics have been covered, and I think our startups who have participated in this webinar, they must got the complete learning about the IPR, and they will be more enlightened about the subject. And we have seen that thousands of questions were there in the chat box. So definitely some of the questions have been taken up, but we will try that the other questions which have not been taken up, we can give you the reply maybe through email, or you can contact the secretariat of the chamber, which can give it to the proper reply of the questions. We will take up with the panelists. So it's a great discussion. I would like to thank each and everybody who have participated in this webinar from the different part of the country, and some of the international attendees were there also. It's a great honor to ASSOCHAM also that the kind of attendees, the kind of panelists have joined with us. And then we have sponsors who have supported us. So I would like to thank you all the sponsors, the Angel Fund, what I can see, Mumbai Angels, and the 10,000. I think then startup began in Thai, Delhi, NCR, your story. So the sponsor NDIM, who is our incubation partner. So it's a great, I think, platform where we have discussed in detail about the idea. And in the last, I would like to thank you to the Secretariat of ASSOCHAM. I think they have done wonderful job. I think this is a remarkable job, inviting such experienced speakers from the different backgrounds, and then organizing the complete webinar. So I would like to thank you to Ajay Sharma ji and the Robinson and Mr. Robinson and the other team members for their hard efforts and organizing this webinar. I would like to thank you to all and everybody for joining with us. Thank you very much. Thank you once again and namaste.
All right, thank you.
Thank you, Ji. Thank you. Now come to an end of the session and request everyone to log off.
Thank you, Jay.